Lords, I was dealing with the Tyburn case and just coming on to Mr. Rayner James's submission at page 82 of the report, which was that the Mozambique principle should be confined to land and not expanded to deal with IP rights. A submission which was rejected by Mr. Justice Vinelot. Then there's a passage at the bottom of page 8 which my learned friend drew your Lordship's attention to, where Mr. Rayner James accepted that no distinction could be drawn for this purpose between patent rights, copyrights and trademarks and so on. And although that concession was seized upon by the Court of Appeal in Ove Arup as being a possible explanation for why Mr. Justice Vinelot came to the conclusion he did, or at all events an explanation for his decision, in my submission, that was an entirely proper concession to make, an entirely reasonable concession to make, an entirely correct concession. There is, for present purposes, no realistic distinction between them, as indeed Mr. Justice Laddie recognised in the coin controls case, which I pointed your Lordships to earlier. And then Mr. Justice Vinelot, at the bottom of page 9, also makes the point that Lord Herschel founded his decision on the distinction between transitory actions and actions which are in their nature local. He did not in terms restrictive actions claiming title to or damages for trespass to land. And then on the next page 10, I don't think I need to cover the Lordships at all, because that's coming on to do with the different issues. The Lords, my overall submission on the Tyburn case is that it was a carefully considered decision by a judge who knew something about IP rights and who evidently took it, despite arguments to the contrary, as being pretty well self-evident that the local rights point applied to all intellectual property rights, whether in an infringement action or a mere validity action, or rather, whether or not validity came into it. Now, Lords, if we go back to Ove Arup at tab 26, and look at page 30, I would submit that they passed too lightly over what Mr. Justice Vinelot said. His decision was a carefully considered one, and to consider it by reference only to its headnote, and to say that they didn't find it necessary to decide whether he was correct in the view he took, is, I think, to dismiss it too lightly. And similarly, on the next page, 31, they consider a case in which Lord Justice Dillon said, and the quotation's there, but from the nature of a United Kingdom patent, and I'm taking it from the middle of the quotation, but from the nature of a United Kingdom patent, proceedings for infringement of a United Kingdom patent can only be brought in the United Kingdom court, in the present case the English court, and can only be founded on infringement in England. The German court could entertain an action for infringement of the comparative German patent, comparable German patent, but couldn't entertain a claim for infringement of an English patent. Conversely, the English court could not entertain a claim for the infringement of a German patent. English law, as embodied in the Patents Act, is founded on international conventions, not just the European Community Convention, but subject to special provisions. Its application by the English court is a matter of English law. Defendants, of course, and then turning to the decision, the defendants, of course, seek to rely on the observation of Mr. Justice Dillon. It's unnecessary for us to express a view whether that observation was correct, but we note that it was plainly obiter. Well, it was, that's perfectly true, in that there was no claim in the action so far as appears from the report in respect of alleged infringement of the German patent, if indeed they had one. And then, that the question does not appear to have been the subject of any argument, neither the Mozambique case nor Potter's case referred to in the report. Well, that's true as far as it goes, But I would submit the fact that Lord Justice Dillon regarded it as essentially self-evident and in need of no authority only serves to show how established this principle has always been in English law. As a result of, as the Court of Appeal says, it was on the basis of, on the next page, the basis of Lord Justice Dillon's observations in the Molnicker case that the Court of Appeal in Boston Scientific sent a pertinent question off to Europe. So I won't trouble your lordships with the question, but move on to what was said by them about the Berne Convention. Encouraged perhaps by the reference made by this court in the Boston Scientific case, defendants contended that provisions of the Brussels Convention are excluded by Article 57 from application of copyright infringement by the provisions of Article 5.2 of the Berne Convention. And then they quote that. The argument being, as I understand it, that because the Berne Convention says that, well, at least the argument which was being presented to the Court of Appeal, and was that because the Berne Convention says that when you sue on a copyright in a foreign state, the law applied is the law of that foreign state, then the argument was that implies, so to speak, that the action should be brought in that foreign state, not somewhere else. Now, whether that's a good argument or not is another matter. But what I would draw attention to is that the Court of Appeal came to a rather odd conclusion about the Berne Convention, which again, in my submission, suggests that they, with great respect, didn't really understand IP law. Because they said this. We note that although the Berne Convention, unlike the EPC, was in force at the time when the Brussels Convention came into effect, it's not referred to in the general report. I think there's a good reason for that. Article 5.2 of the Berne Convention doesn't purport to govern jurisdiction in relation to infringement of copyright. Well, that's true. National law in the context of Article 64 of the Patents Convention means the law of the state in respect of which the patent is granted. Perfectly true and obviously right. But in relation to copyright, the question is not in respect of which country is the protection claimed, but where is the protection claimed? The protection is claimed in the country in which the proceedings are brought. Article 5.2 requires that the extent of the protection to be afforded is governed by the laws of the country in which the proceedings are brought, which is, with respect, a quite extraordinary notion. But if you are to have foreign enforcement, or rather English enforcement of foreign rights, you're going to apply English law to it, and their notion was that the Berne Convention requires you to apply English law to it. Now that too, in my submission, is an evident misapprehension of what the law must obviously be, and it casts further doubt, I would submit, on the authority of this whole decision. But in the end, the main point is that they didn't decide the point anyway, as I've already shown the Lordship on page 30. They said it wasn't necessary to decide the point that I would say Justice Weinlott certainly did decide, and decided rightly. That point on the Berne Convention perhaps is an appropriate point to deal with the point Lord Collins raised about the Rome II Convention. I hope I haven't pinched your copy. I don't think so. The first point on Rome II is it didn't come into force until, I think, 2009. But that perhaps is not the reason why it was put to me. If I understand the point correctly, it may be this, that the existence of Article 8.1 is in itself an indication that there are countries which are contemplating allowing IP suits relating to the laws of relating to the IP rights effective in other countries. Because Article 8, which is Article 8 is talking about proper laws of well, the whole convention is concerned with proper law in relation to tort or non-contractual claims. And Article 8 is dealing with the proper law to be applied in the case of IP claims. So it is apparent from Article 8 that the notion has got about that there may be cases in which states will be trying foreign IP claims. Well,
including the United Kingdom.
Including the United Kingdom, indeed, because this is a convention that applies to us. But the first point is, of course, that this convention is not conferring jurisdiction on anybody. It's merely saying that if jurisdiction does exist, then a certain proper law must be applied, and very sensibly, Article 8.1 says, if you are considering a foreign intellectual property right, then the law you will apply to it is the law applicable to the territory to which that IP right appertains. One could hardly imagine anything more stupid than a law that didn't say that, though, with great respect, that seems to be what the Court of Appeal was saying in Over Yarrop when it discussed the Berne Convention. So that's all Article 8 says, and insofar as it is contemplating the possibility that there may be such actions taking place, we don't know whether it was contemplating the possibility of extra-community rights being sued on. It's perfectly true that the Convention as a whole covers all actions brought within, all kinds of claims. But it doesn't follow from that that all the claims potentially covered by it actually exist, or jurisdiction exists. It is simply the case, all Article 8 is saying is that if you've got jurisdiction to consider a foreign infringement claim, then you apply the foreign law to it. And of course, in fact, under the Judgments Convention regulation, there will be foreign IP actions brought in community courts. And Article 8.2 goes on to deal specifically with the situation when at last there are unitary community intellectual property rights, and it deals with it just slightly differently. But this, I would submit, is not saying anything about it is not recognising that there are in fact any such possible actions. The next and perhaps most subtle way in which the point can be put against me is that it might be said, if my learned friend is right, that the whole principle I'm relying on relies on some kind of international consensus for its existence, then that article indicates that there is no such international consensus. Well, as to that, I've got 2 points. Firstly, it doesn't say anything about any absence of an international consensus except in relation to Europe, because we know in relation to Europe things have now changed. But secondly, and more importantly, so far as English law is concerned, the international consensus was one which existed, I think, something like 100 years before the Mozambique case was decided. In the Mozambique case, it was assumed that that consensus continued to exist, and so far as the US was concerned, it did. The second rule in the Mozambique case was extensively criticised. And by the time the matter came before the House of Lords in the Hesperides case, at that stage, the consensus, it would seem, was severely shaken. Yet the House of Lords decided that it would not be right to displace an existing principle of English law, which may originally have been developed for the purposes of, or rather as a result of some international consensus. It was not right to mitigate that rule in the light of current standards. The law should be left as it was, because there were at least some countries within the Commonwealth that still followed it. It was long established in England, and the English court, the House of Lords refused to change it. Now, that was a part of the Mozambique rule that certainly was controversial and did potentially give rise to injustice without any particular need for the rule to exist. Here, we're talking about an established rule, soundly based on the local action doctrine, which even today has very sound policy reasons to support it. It is not some old-fashioned hangover. It is a rule which Mr. Justice Aldous, Mr. Justice Laddie, Mr. Justice Vinelot all saw great virtue in. It is a rule, as we shall see when I look at the American cases, that at least some Americans also see great virtue in. And in my submission, even if the universal consensus has now gone, as indeed it had in Hesperides, that is not in itself a reason to depart from an established rule. Maybe this is the moment for your lordships to see the South African case in Bundle 3, tab 25. In which the South African Supreme Court of Appeal if we go to paragraph 4, the contentious part of the particulars of claim relates to the allegation that defendants have also committed acts of infringement in a large number of other countries, 19 in all, from Japan to the east to the USA and the west. Important to stress, in relation to these infringements, plaintiffs did not rely on our Copyright Act, but the copyright laws of each of those countries. Particulars in relation to each country are in similar terms. It would suffice if one country, say the United Kingdom, is given as an example. And then they set out the law in relation to that. And then they go through the jurisprudential position in some detail. Coming on at paragraph 22 to say Lucasfilm, as mentioned, dealt with exactly the same issue that concerns this court. Although UK courts had personal jurisdiction, the question was whether they had subject matter jurisdiction. It's not necessary to traverse all the reasoning which led to the court to the conclusion that a UK court didn't have jurisdiction to decide the matter. For present purposes, it suffices to point out that the court applied a jurisdiction rule applicable to removables, which is for all intents and purposes the same as the rule in ILON to copyright. The rule derives from British South Africa. The rule was affirmed in Hesperides, and then he refers to Mr. Justice Laddie. Paragraph 25, the court in Lucasfilm also had regard to practical considerations as to why a local court should not exercise jurisdiction over foreign copyrights. In other words, the court was able to justify its conclusion not only on principle, but also on the grounds of convenience and common sense. These considerations include the fact that enforcement may include a clash of the IP policies of different countries, that extraterritorial jurisdiction involves a restraint on actions in another country, an interference which prima facie a foreign judge should avoid, and it will create too much room for foreign shopping. And they dismissed the appeal with costs. Perhaps if your lordship would turn back to paragraph 15, they refer specifically to the fact that intellectual property rights are territorial in nature. And it is also, of course, significant that the South African jurisdiction is not, strictly speaking, a common law jurisdiction. Also, this is an instance of a very senior court giving effect to the very principle I contend for here. And it doesn't lose its authority by reason of the fact that it's following the decision which is appealed from here. It follows its logic and it approves it It doesn't just rubber stamp it. The South Africans thought carefully about it, considered the underlying logic, and applied it to a different system of law. Let me now look briefly at the American situation, because as we've seen, the American situation is firstly, the ALI report. I don't want to take your lordships through it in detail. What I would say about that is that it is not a statement of the law. It is a pious hope by those propagandizing for the view that there should be wide jurisdiction to hear foreign intellectual property actions. It may be, in the end, that legislatures will adopt the principles it puts forward. It, I hope, would be the case that legislatures will not do so until there's been some degree of harmonisation of IP laws to make it practically possible to do that. But that, as I say, is not a statement of the law. Much more important are decisions and articles saying what the commentators consider the law to be. And can I take your lordships to four indications of that? Patry on copyright, bundle 3, tab 6. He says in the first paragraph on the, if you should go through in the clip to where the text starts, he says, in cases where, under both a conflict and contributory infringement analysis, the United States lacked sufficient contacts to either the subject matter or the acts of infringement to assert jurisdiction, some courts have nevertheless been unable to resist the temptation to act as a world forum for copyright infringement. The first court led astray was London Film Productions against Intercontinental Communications, which asserted diversity jurisdiction over foreign acts of copyright infringement. In London, the court adjudicated alleged infringement by an American corporation in several South American countries of a British corporation's copyright. And then based itself on the notion that the court has an obvious interest in securing compliance with this nation's laws by citizens of foreign nations which have dealings with this jurisdiction. A concern with the conduct of American citizens in foreign countries is merely the reciprocal of that interest. An unwillingness by this court to hear a complaint against its own citizens with regard to a violation of foreign law will engender, it would seem, a similar unwillingness on the part of a foreign jurisdiction when the question arises concerning a violation of our laws by one of its citizens who's since left our jurisdiction. The court's interest in adjudicating copyright infringements by foreign citizens that occur in the court's district is statutorily provided for by Congress. Nothing a foreign court could do would affect that power. Conversely, if an American infringes a British work in Britain, the British courts will hear the claim because they too would be wanting to pursuant to a domestic statute. British courts certainly would not decline to hear such a case because at some earlier time a US court had refused to hear a case against an American citizen for infringement of a British work that occurred in Chile. In London Film Productions, there was no US copyright violation because the work was in the public domain here. Should we expect a British court to hear a case brought by a United States citizen involving an alleged infringement of copyright in South America by a British citizen when the work is in the public domain in England merely because the bad boy was British? If so, we would have been sorely disappointed. At the time of London Film Productions, English courts declined jurisdiction over British citizens' claims. And then at the bottom of the next page, regrettably, a number of subsequent courts have also mistakenly relied on London films for the transitory tort proposition. These decisions are all distinguishable. And perhaps I should read this at the top of the page. Diversity jurisdiction was supposedly justified by copyright infringement being a transitory tort. Why is copyright allegedly a transitory tort? Because it was declared that copyright is an incorporeal form of property and therefore has no situs apart from the domicile of its proprietor. This is a quote from London. Presumably, if the proprietor moves, the situs of the property moves too. However, if the proprietor doesn't move, the situs must remain with the proprietor. In London film productions, this meant in England, indicating England, not the United States, was the appropriate jurisdiction. Under this reasoning, a United States court would never have jurisdiction to hear a claim of infringement of a foreign copyright unless the foreign copyright owner was domiciled in the United States. Copyright is not a personal right which attaches to the individual and follows him or her wherever the individual travels. Instead, it is a territorially derived property right which exists by virtue of a national grant. Whether another nation decides to grant a similar property right is a matter for the legislation in each nation. Transitory torts are personal rights, not property rights. This characterization confuses the incorporeal nature of the copyright property right with personal rights. The two are quite different and the consequence is quite different too. Copyright protects only rights in works, it does not protect authors. As a property right rather than a personal right, copyright cannot be a transitory tort. And in my submission, that is absolutely right. It is a territorially, strictly limited tort. It is not a transitory tort which can be which is independent, so to speak, or as the definition put it, which is based on things which could have happened anywhere. Then, Lords, there is an article by Torrea at tab 3. Tab 9, so sorry. And I can jump straight to page 5, I think. Critique. Professor Nimmer's administrative formality distinction renders prior decisions involving patents and trademarks inapplicable to the jurisdictional requirement of determination of foreign copyright actions. His theory draws a bright line between the appropriateness of adjudicating the validity of foreign intellectual property rights that need administrative formalities to create or perfect them, and those that do not. The decision whether to accept jurisdiction is conditional solely upon whether an American court must pass upon the validity of administrative acts undertaken by foreign officials. This methodology, as applied by the London Film Court, assumes that the foreign state is interested only in preserving the presumption of administrative correctness of its acts in infringement cases. A court's refusal to accept jurisdiction is therefore based upon the act of state doctrine. And then it goes on to say, this reasoning oversimplifies the jurisdictional determination. The administrative formality distinction focuses on a characteristic common only to foreign trademarks and patents, and in doing so appears to give greater weight to a foreign state's interest in its trademark and patent laws to the exclusion of its copyright laws. This distinction ignores the similarity of the public interest sought to be advanced by copyright, patent and trademark laws. A foreign state's interest in infringement adjudication extends to ensuring that its policies are promoted through proper application of the law. The presence or absence of an act of state necessary to perfect or create a foreign copyright should not be the determining factor in deciding whether to accept jurisdiction. The Lordships will note there the reference to policies and the fact that in this case we've seen two systems of law, the English and the American, which have somewhat different policies for the handling of functional articles. Lords, moving quickly on to the ITSE case, tab 27 in the same bundle, ITSI. Here, the plaintiff was an Illinois company doing business in California. It supplied the defendants with closed-circuit broadcasts of horse races, and the defendant was apparently airing its feed of the races in Mexico in violation of its copyright. And what was alleged was that that was an infringement of American copyright for various reasons, and that failed. And what was, we see that on page 15, just above Romans 6, because the plaintiff has failed to demonstrate that Caliente committed a direct act of copyright infringement in the United States, this court lacks subject matter jurisdiction over plaintiffs' claims against Caliente. Then the allegation was made that there was an application of an infringement of Mexican copyright law. Plaintiff suggests that if Caliente is not liable for an act of infringement which occurs in the United States, the plaintiff should be given leave to amend its complaint to state a cause of action against Caliente under Mexican copyright laws. This position has gained some support amongst academics, see Goldstein, and so on. And then there's a reference to, although one district court has accepted jurisdiction over an action for foreign copyright infringement, see London, I discern no clear authority for exercising such jurisdiction, see generally David Toroya. Moreover, it appears to me that American courts should be reluctant to enter the bramble bush of ascertaining and applying foreign law without an urgent need to do so. No such reason has been tendered in this case. As a matter of common sense and judicial restraint, I think it appropriate to decline the plaintiff's invitation. Most important of all is the Voda and Cordis case at tab 35. This is important because it's a decision of the United States Court of Appeals for the Federal Circuit, which is a specialised tribunal hearing appeals in patent cases and customs appeals and various other specific jurisdictions, but in particular patent cases. So this is a tribunal that really knows about IP questions. And if I could take your lordship,
with a dissent by quite an eminent judge.
There was. I don't dissent. I don't ignore the fact that there are two views on this. There are two views about the desirability of it. There is, I would submit, only one view about what established law in this country is. Going on to 901, the considerations which impressed the heading at 897. Oh, sorry, like heading at 897. Patent holder brought infringement actions against.
No, at 897 you'll see the heading is discretion.
Oh, sorry, 897. No, the friend wants discretion. Section 1367 reaffirms that the exercise of supplemental jurisdiction.
No, I'm only asking you to be attention to the heading under which
this was decided. This was all decided under the heading of the discretion to exercise supplemental jurisdiction, which is conferred upon the district court. And in exercising that discretion, on page 898, there's a reference to the considerations which might be in the court's mind, but I'd like to turn straight to page 899 to speed things up a bit. About 7 lines down the left-hand column on 899, nothing in the Paris Convention contemplates nor allows one jurisdiction to adjudicate the patents of another. As such, our courts should not determine the validity and infringement of foreign patents. Accordingly, while the Paris Convention contains no express jurisdiction stripping statute, we relied on it in Stein to hold that only a British court applying British law can determine validity and infringement of British patents. And then at the top of the next column, there's a reference to TRIPS. The agreement on TRIPS contains several provisions regarding the enforcement of patents. Article 41, paragraph 1 of the agreement on TRIPS specifies that each country shall ensure that enforcement procedures as specified in this part are available under their law, so as to permit effective action against any act of infringement of intellectual property rights. Note the generality of that, covers copyrights as well as patents. And then down at the bottom, Voda asserts, and one of the amicus curiae briefs suggests, that these international treaties evince a trend of harmonising of patent law, and thus that allowing the exercise of supplemental jurisdiction over Voda's foreign patent infringement claims furthers the harmonisation goals underlying the treaties. Regardless of the strength of the harmonisation trend, however, we as the US judiciary should not unilaterally decide, either for our government or for other foreign sovereigns, that our court will become the adjudicating body for any foreign patent with a US equivalent, so related to form the same case or controversy. Permitting our district courts to exercise jurisdiction over infringement claims based on foreign patents in this case would require us to define the legal boundaries of a property right granted by another sovereign, and then determine whether there's been a trespass to that right. And the same, in my submission, applies equally to copyright, which is a right granted by the sovereign parliament in this country. Based on international treaties that the US has joined and ratified as the Supreme Court law of the land, a district court's exercise of supplemental jurisdiction could undermine the obligations of the United States under such treaties, which therefore constitute an exceptional circumstance to decline jurisdiction under paragraph 1367. And then comity in relation between sovereigns. I can, I think, jump to paragraph 6 at the top of page 901. In this case, these considerations of comity do not support the district court's exercise of supplemental jurisdiction over Voda's foreign patent infringement claims. First, Voda has not identified any international duty, and we have found none, that would require our judicial system to adjudicate foreign patent infringement claims. As discussed above, while the United States has entered into the various conventions, nothing in those treaties contemplates or allows one jurisdiction to adjudicate the patents of another. Second, as discussed below, Voda has not shown that it would be more convenient for our courts to assume the supplemental jurisdiction at issue. Thirdly, with respect to the rights of our citizens, Voda has not shown that foreign courts will inadequately protect his foreign patent rights. Indeed, we see no reason why American courts should supplant British, French, German or Canadian courts. Sorry? What point did you just Fourth, assuming jurisdiction over Voda's foreign patent infringement claims could prejudice the rights of foreign governments. And then we come to perhaps the most pertinent point for present purposes, at the top of 901. In addition, the local action doctrine informs us that exercising supplemental jurisdiction in this case appears to violate our own norms of what sovereigns ordinarily expect. Courts derived the local action doctrine from the distinction between local and transitory actions, beginning with Livingston and Jefferson, and then he describes Livingston and Jefferson. The Supreme Court subsequently held that an action for trespass upon land, like an action, more about that, the court concluded that a federal court sitting in another state had no jurisdiction to hear the trespass claim. In short, the local action doctrine served to prevent courts from adjudicating claims for trespass to real property. The territorial limits of the rights granted by patents are similar to those conferred by land grants. And exactly the same is true of copyright. A patent right is limited by the metes and bounds of the jurisdictional territory that granted the right to exclude. Citations for that. Exactly the same considerations apply to copyright. Therefore, a patent right to exclude only arises from the legal right granted and recognised by the sovereign within whose territory the right is located. It would be incongruent to allow the sovereign power of one to be infringed or limited by another sovereign's extension of its jurisdiction. Therefore, while our Patent Act declares that patents should have the attributes of personal property and not real property, the local action doctrine constitutes an informative doctrine counselling us that exercising supplementary jurisdiction over Voda's foreign patent claims could prejudice the rights of foreign governments. Therefore, the four considerations enunciated by the Supreme Court in the case referred to demonstrate that extending our jurisdiction through 1367A in this case could undermine the spirit of cooperation underlying the comity doctrine. Pausing there, the point, as I understand it, about the discretion is that the discretion was a discretion to consider cases which the court wouldn't normally have jurisdiction, would not normally be considering. And they're saying, because we don't have jurisdiction in the ordinary way, we will not exercise our discretion to deal with it under our supplemental jurisdiction. But this is a clear finding that in the ordinary way, the local action rule applies to patent actions, expressed in a manner that applies equally firmly to copyright actions. And then, if you go to the bottom of the next column on page 902, we come on to points which might be categorised as policy points, but they are, I would submit, highly material in considering, when your lordships consider whether it is right to allow the local action doctrine to continue to apply to IP rights. We would risk such interference by exercising supplemental jurisdiction over Voda's foreign patent infringement claims. Patents and the laws that govern them are often described as complex. Indeed, one of the reasons cited for why Congress established our court was because it felt that most judges don't understand the patent system and how it worked. As such, Cordis US, and one of the Amicus Curiae assert, and Voda doesn't dispute, that foreign sovereigns at issue in this case have established specific judges, resources and procedures to help assure the integrity and consistency of the application of their patent laws. Therefore, exercising jurisdiction over such subject matter could disrupt their foreign procedures. Incidentally, it happens to be the case that copyright cases are assigned to the federal jurisdiction in the States, not exclusively assigned to the federal jurisdiction in the States. They can't be heard in state courts. By analogy, Congress unified our patent jurisprudence by creating the Federal Circuit and granting exclusive jurisdiction on appeals on patent claims. But it isn't the case that the Federal Court, the Court of Federal Appeals hears copyright cases, it's fair to say. Accordingly, going to the bottom of that paragraph, comity and the principle of avoiding unreasonable interference with the authority of other sovereigns dictate in this case that the District Court decline to exercise the supplemental jurisdiction. Then, judicial economy. Because of our lack of institutional competence in the foreign patent regimes at issue in this case, more judicial resources could be consumed by the District Court than the courts of the foreign patent grants. Indeed, adjudication of Voda's British, Canadian, European, French and German patent claims may substantially predominate his US patent claims. Now that is equally true of copyright. And one mustn't lose sight of the fact that although in this particular case the claimant is not within the American jurisdiction to be sued there, the principle Melania Friend contends for will have the sort of result which was contended for in the South African case of giving rise to perhaps 19 concurrent copyright actions at the same time in the South African court. That's what Melania Friend is contending for, and the American court here is saying that the lack of institutional competence to deal with such things is a policy reason for not doing what they were invited to do. And I would submit it is an equally strong policy reason in this court at this stage of development of international IP law.
This was a case which would have involved the validity of the foreign patents, wasn't it?
Quite possibly, Lord, yes. Yes. That I would submit is not a factor which is conclusive, or in fact is not relevant in the local action question. It's no more relevant to patents than it was to land law in the Mozambique case.
In the field of copyright, when if ever, is it appropriate to talk about validity?
Subsistence, I suppose, and actually in the present case, I suppose, in a sense, it's not exactly validity which the court was concerned with, but the Section 51, Section 52 points are almost comparable to that. Is there a right there? It's asking, is there a right at all, or has the right been for some reason extinguished?
Would it be appropriate to talk about validity in those countries like America where you have registration?
Well, I think it's probably just discussing the meaning of words. The substance of it is that registration exists as a principle in the States, but it has been somewhat watered down from what it once was. And as you've seen, you can still sue even if the Copyright Office has refused the registration, but there are procedures you've got to go through to deal with it. So it's getting close to a deposit system. Though, curiously enough, deposit systems are recognised in the Brussels Convention as one of the heads of IP right that are dealt with under Article 22. It's registered or deposited, if I remember rightly. Now, I think it might well be said that American copyright law depends on something analogous to deposit, if not positive grant or registration. So It is perhaps a rather puzzling question where American copyright law fits in the context of Article 22.
It's very common to have patent actions relating to essentially the same patent in numerous countries. Now, is that because of the universality of some sort of local, some principle akin to this throughout Europe, or what?
I would say that until the very recent developments such as the Dutch taking on, and I think that's now been severely curtailed, but at one time the Dutch took upon themselves the right to issue international interlocutory injunctions in patent cases. But that's a very, very recent development, probably inspired by the Brussels Convention. But prior to that, it was just second nature to all IP lawyers, and I think all lawyers, that IP rights were sued on in the territory to which they appertained, and that was that. Patent actions were always brought in their individual countries. And there are many, even within Europe, there are many instances of cases sued on in different countries under the same patent, and in which different countries came to different conclusions about validity or infringement. Entirely possible conclusion. It would be much better if there was a unified jurisdiction, and if the European Patent Convention comes into force, such a thing will indeed happen. There's already community trademark courts which provide a degree of unification for the jurisprudence of the European trademark. The European Trademark Court, which are national courts, sit as European trademark courts and will grant injunctions covering the whole of Europe on a European trademark, or for that matter consider the validity on a Europe-wide basis. But this is all recent law, and it's fundamentally based on unification of the system of law applied. And when you do that, it works. It makes sense for one court to grant an injunction covering the whole of Europe if it's the same trademark right and the same legal system applying.
It's only one trademark.
Yes, it is. It is only one trademark, and the hope is there will be a community patent convention. It's taken. We've been waiting for it for 40 years since the 1977 Patents Act came out, which was rather expecting a community patent to come along quite soon. Still hasn't got there. But
the European courts decided something yesterday, I think.
I was thinking of other things yesterday.
I think it's just decided that there's a problem of competence in relation to the creation of some sort of unified patent court.
Oh, Lord. Right. Well, one of the problems is, of course, that the European patent system is wider than the European community. Not only does it cover the old EFTA countries, but it also covers countries outside that, like Turkey. So the European Patent Court has a wider jurisdiction. What's contemplated is that there should be a community patent or sort of a community patent convention carved out of the wider European patent, and that community patent court would deal with a community patent as if it was a British patent, but it would be a European patent. But I didn't know the European Court had decided a problem about that. Anyway, but
temporarily scuppered that.
But what all that illustrates is that it's putting the cart before the horse to start trying to give jurisdiction to national courts before they've got the unified law that enables them to handle foreign laws without undue difficulty. And one can see that for political reasons there might be some sense in putting the cart before the horse, because it'll force countries to unify their laws. And a politician might sensibly come to such a conclusion. But I would submit that your lordship shouldn't.
I follow the point you're making on difficulty. Are you, in this case, invoking comity?
Comity is one of these words that gets bandied about, like sovereignty.
Quite a lot in this case.
Yes, it is. I think the word comity is used because it's a convenient and emotive way of justifying the underlying local action rule. there's echoes of the same thing in what happened in Potter, where the Australian court concentrated on the sovereign act of granting the patent. But underlying it, I would submit, is the local action rule. And in fact, in Potter, the court below had decided the case on the basis of the local action rule, but the High Court decided to run with it on the basis of the sovereign rights point.
So does that mean the answer is no?
I'm much happier with the local action rule. If I
Isn't
can't win on the
local action rule really comity? It's what the American court said in the case we were looking at. It's for a British court to apply British patent law.
Well, exactly.
Isn't there an element of comity there?
Well, yes, there is. There is an element of comity underlying the local action rule. But the local action rule, though, has an independent existence of comity is one of the justifications, if you like, for the existence of the local action rule. And in the case of IP rights, it is a justification which still has very much lively force. It seems a justification that had much less lively force in relation to the second rule in the Mozambique case by the time Parliament came to abolish it. But Parliament did not abolish it for patents and IP rights. It was left intact when it was specifically abolished in relation to land law. Lords, can I very, very briefly deal with a on this basis? Oh, sorry, I did mention this morning the Section 25 point. I think I've mentioned that sufficiently to raise the issue. It is, I would submit, one good reason why there's no need to go to the lengths my learned friend would invite you to go. The existence of Section 25, which has not been used for this purpose yet, but there's no obvious reason why it shouldn't, is in itself a good reason why there is no pressing need to take the action sought by a learned friend. Section 25 provides a useful and, whilst not comprehensive, nevertheless much more convenient approach to dealing with these problems.
Is it in the Voda case, I may be taking it out of context, but is it of any significance that Judge Newman, who dissented, when he's discussing the local action doctrine, does so on the basis that it shouldn't prevent a US court from adjudicating a dispute between two US parties? In other words, there's personal jurisdiction there. That's at page 914.
Yes. Well, if that is, well, I think it is.
In other words, that's not this case.
It's not this case, though I'm not sure there's a principled distinction between a case where both parties are US parties and a case where the foreign claimant is the case. One would have thought it was the presence of the defendant in the US that really counted, which is not a point in my favour, I've said. But I think more to the point, the local action doctrine never was qualified by reference to the domicile of the parties. Most of the local action cases are indeed cases where the parties are domiciled in this country. That's why the action was brought here in the first place. So, Lords, I say that the Court of Appeal got it right on this, for the right reasons, for reasons which are not based on some old-fashioned principle. It is an old principle, it is an old established principle, but it is a lively principle of great importance and great continuing utility, from which your Lordships have no adequate reason to depart. It brings me on to deal very quickly with the Owusu case. The Owusu case was a case about in personam jurisdiction, not subject matter jurisdiction. It does not follow from the Owusu case that because Owusu had to be entitled to continue to sue in England, the same applies in the present case. One can, of course, see reasons why the European Court might say, nevertheless, that it should, but one cannot, I would submit, ignore the extraordinary consequences which would follow if the present case and other such cases have to be sued on here. There's the problem of real property in a non-contracting state. indeed all the points in Article 22. Article 22 sets out some common sense exceptions to the general principle of jurisdiction based on domicile. Those common sense exceptions are all limited to cases where the exception applies in another contracting state. For example, ownership of real property in a contracting state has a special rule attached to it, albeit, as my learned friend rightly points out, somewhat cut down by judicial decision. But the rule, such as it is, or the exception such as it is limited to contracting states. It follows that unless one indulges in some kind of judicial reflexive is the word used, but it's a word used for the purposes of this particular problem. Unless one construes the convention in a very peculiar way to say that when it says contracting state, it also means non-contracting state, although the convention recognises that a French real property action must be brought in France, even against someone domiciled in England, a New York piece of property, if somebody in England is sued in relation to it, the person in England cannot avoid the continuation of that action. He cannot say the forum non-conveniens doctrine applies, this should go off to New York, at least as the words of that convention say. My submission is that the way round that is the way adopted by the Court of Appeal, that in relation to matters which have nothing to do with the community, if the English court has got jurisdiction, as they did over Owusu, then of course the convention applies, and the in personam rule in Article 2 applies. The action must proceed. But in cases where, as a matter of English domestic law, there is no subject matter jurisdiction, then the English court is clearly entitled to say, Owusu doesn't cover the situation, the convention was never intended to cover the situation, and doesn't. The fact that Article 2 is not as absolute as it appears is established by the Correc Maritime case in Bundle 5 at tab 10, and to save the Lordship's time, I think we want to take the Lordships through it, but paragraphs 19 and 20 seem to be saying in the case of contractual assignment of jurisdiction to a non-contracting state, Article 23 of the Convention says that assignments of jurisdiction to a contracting state must be recognised, or in certain circumstances they must. The Correc case involved a contractual assignment of jurisdiction to a non-contracting state, a common enough situation, one might think. Now, if Owusu applied to that situation, then a contractual assignment of jurisdiction to a non-contracting state is wholly ineffectual, because Article 23 says nothing about contractual assignments of jurisdiction to a non-contracting state. On the face of it, therefore, Article 2 applies, and therefore the state in which the action is brought must continue to hear it. But in Correc Maritime, in paragraphs 19 and 20, the European Court seems to be saying, though it's fair to say it's not absolutely 100% clear, but it seems to be saying that the contractual assignment to a non-contracting state must be respected. Now, if that's right, it's opening the door to what amount to exceptions to Article 2. And if that exception to Article 2 exists, there's no reason why an exception shouldn't equally exist in relation to IP rights. And I would say in relation to IP rights generally, because although within Europe a special regime has been devised in Article 22 to deal with IP rights in Europe, there's no reason why the minutiae of that particular exception, which reflects, for example, the odd German distinction between infringement or the place where infringement is heard and validity is heard, there's no reason why that should be applied to extra-community situations. I would submit that the easy way to deal with it is that if the national court, on the basis of its own national law, has no jurisdiction at all, then there is and the correct jurisdiction is outside the community, then the Convention does not apply at all. Article 2 does not apply. The domicile point simply doesn't arise. That's what the Court of Appeal said, and in my submission that must be right. Then one final example of an absurdity which would otherwise apply is the question of inquiring into the acts of foreign sovereigns, Butts, Gas and Hammer. Could that be something which must now be dealt with on the basis of Article 2? Because Article 2 has an absolute, confers not only personal jurisdiction but also subject matter jurisdiction, even in a case where the House of Lords has said that it is inherent in the judicial process that one won't inquire into the doings of foreign sovereigns. It would, in my submission, be odd if a convention passed for the purposes of regulating within the community the rights of people within the community should interfere with a point like that.
But if you put your case on the basis of local and transitory actions, then that sounds very much like the kind of jurisdictional issue that might be caught by Article 2, whereas if you put it on the basis of non-justiciability, and the result might be different.
But non-justiciability in the Butts, Gas and Hammer point?
Well, in the Potter, in the Potter case, it's really non-justiciability. It's not it's gas. No, because that's transactions between sovereign states, but the out-of-state doctrine.
I don't see a difference between I would say Potter was a jurisdiction case. If I'm
well, it's got elements of both, hasn't it?
In the sense that it's inquiring into the doings of a foreign sovereign.
Yeah, there's a lot of talk about out-of-state doctrine there.
Yes, I think, well, I think with respect, it's not necessary, certainly for the purposes of the English argument, it's not necessary to make use of the justiciability point. If, in the context of Owusu, justiciability is the only exception which could be relied upon, then it may be necessary to deploy that by way of an answer to Owusu. With respect, I don't see why it should be more of an answer to Owusu than simple lack of jurisdiction. It perhaps makes the point more pointedly, but either Article 2 is absolute, in which case one would have thought it covered judiciability as well as jurisdiction, justiciability as well as jurisdiction, or it's not. And if it's not, then there's no reason why all sorts of common sense exceptions shouldn't come flooding into the, or shouldn't start subtracting from the otherwise absolute effect of Article 2. Either there is no exceptions at all, including justiciability, not even justiciability, or there are plenty of them, and common sense suggests that there must be plenty of them.
Isn't this a point we'd have to refer?
The Court of Appeal evidently thought it was Act Clare.
Thought it was Act Clare.
And I suppose there does come a point where such absurdities result, if you don't come to a particular conclusion, that you could say that it was Act Clare. But subject to that, I have to concede that it's not an easy point, given the existence of Owusu. Owusu itself is so daft that one might have thought that was Act Clare had it not been decided in the way it was. Lords, I think I've rather overstepped my time, and I apologise to my own friend for that. Unless there's anything else I can useful to say.
Thank you very much, Mr. Hayman.
My Lady Hale referred to Judge Newman as he. I'm sure she would be the first to want to know that Pauline Newman is a lady.
Well, I knew there was Pauline Newman, but I also knew that there's a Judge Newman, John Newman,
Yes.
who's also a federal judge. He doesn't only do intellectual property cases, he does all sorts of stuff.
Yes.
But he's such a wise man that I did want to read what was said.
Well, it's a very
Was
good...
Chief Judge, Jon spelled.
Yes, that's right.
It's a very good dissent. I'm looking, with the assistance of those behind me, at the internet biography of Pauline Newman. It seems to be the same person. But,
Well, it could easily be. I gathered that from the reference to her. How interesting.
I propose in my reply to deal with three matters relating to English copyright. First of all, the dividing line between the functional and the artistic. Secondly, the question of works of artistic craftsmanship. And thirdly, section 52. I shall then, if I may, pick up a small number of discrete points, mainly by way of correction to things that my learned friend said in relation to jurisdiction. First of all, then, the dividing line between the functional and the artistic. My learned friend and I are agreed that there is a distinction between them and that it is fundamental to the issue that we are debating. The difference between us appears to reside in two related points. First of all, my learned friend commends the elephant test and invites you to decide this case by saying that an onlooker would never say about the stormtroopers, there is an actor wearing a sculpture. He would say there's an actor wearing a spacesuit. Secondly, the closest that my learned friend gets to putting forward a test of sculpture is to say that when a three-dimensional object has both an artistic and a functional purpose, the artistic purpose has got to overwhelm the functional one rather than be the primary purpose. Now, as far as the elephant test is concerned, it cannot be enough to decide an issue about the existence of a property right to say, I know a sculpture when I see one, and that isn't it. It is incumbent on a judge to know why he is saying that. And in a field where judgments are highly subjective and variable over both time and from one person to the next, moreover, in a field where artistic quality is excluded by statute as a relevant consideration, then I submit that it is incumbent upon a judge to decide it in a manner that is free of cultural bias and value judgment. That is never going to be possible without a proper framework of principle. The elephant test is just an invitation to personal value judgment and an excuse for avoiding the principle. Now, as to the argument that the sculptural character of the object must overwhelm the functional aspect, the problem I would suggest about overwhelmingness as a concept is that it isn't sufficiently coherent or meaningful to be useful. What I think my learned friend is really trying to say is that the object must either have no, or at least no significant, functional purpose. Now, the difficulty is that before you address that question, there is a prior question that you have to answer, and that is, does the object in question have any function at all that doesn't simply derive from its appearance? If the only function that you can attribute to the object derives from its appearance, then that means that it has no function which qualifies its artistic purpose of making a visual impact on the beholder. On the contrary, on that footing, the alleged function is to make a visual impact and nothing else. Now, unless that is right, then there would be a sufficient degree of functionality to deprive something of artistic status if it had, say, the function of being displayed in a gallery or hung on a wall or decorating a millionaire's hallway. And that was the point that was made by the United States Third Circuit Court of Appeals in Masquerade, and there is no real answer to it in our submission, certainly none that your lordships and my lady have heard from my learned friend.
Isn't there a distinction between something which has the function of being looked at and admired as such or for itself, and the function of something which is actually designed to tell you a story and make you believe that you're in the middle of a story and seeing stormtroopers and evil people and understand the story.
Not a relevant distinction. Your Lordship is suggesting, in effect, that if you have a sculpture or if you have a three-dimensional object that serves a narrative purpose, that may be a function which is a distinct function from being admired in a gallery, because you are admiring it not simply as an object in itself. I respectfully doubt whether that is a workable distinction. There is a very large number of things which one would unquestionably regard as sculptures, both analytically and as a matter of instinct, which have a narrative function. Large numbers of religious sculptures depict scenes. There are reliefs which depict the Nativity, which depict stages in the gospel history. Others of a secular nature which depict a narrative. Now, the fact that they have a narrative function cannot, in our submission, deprive them of the status of sculpture. They only mean that because there is a narrative, you may have a particular reason for looking at them, but looking at them is what the object invites you to do, and that is the relevant factor. Now, the stormtroopers' helmets and armour cannot, in our submission, be treated, as my learned friend sought to do, simply as costumes. The reason why a costume is usually characterized as functional is that, however decorative or eye-catching it may be, its essential function, in the great majority of cases, is to clothe a person, or in a film, to clothe an actor. To keep the actor decent, to decorate the actor in a way that may sometimes serve as part of the storyline by telling you who the actor represents. This is a policeman, this is a soldier, or what have you. But the function is to clothe the actor. Now, in this case, the roles of actor and costume, in that sense, are effectively reversed. The helmets and armour are themselves the object of interest. The sole function of the actor is to move the helmet and armour about in a sufficiently clunking and robotic style. The issue would be no different if the helmets and armour were moved about by remotely controlled machinery within the helmets or armour, or by strings manipulated like a puppet from above. The actor is irrelevant to the appearance of the helmets and armour, except as a mechanism which causes it to move about the set. Now, the essential function of the actor, therefore, is to display the helmets and armour from which the entire visual impact is derived. Now, that could not be more different from the ordinary function of a costume, even in the theatre. Now, the fact to which my learned friend drew attention, that the helmets have eyepieces and other features necessary to make them easier or more comfortable to wear, is no more significant in our submission than it would be to demonstrate that they were fitted with hooks and pegs by which they could be manipulated by strings, or with wheels, engines and radio receivers to enable them to move about by remote control. All of that sort of functionality is simply directed to the display of the object. So you are still presented with an object which derives its functions exclusively from its appearance. The fact that it has a mechanism that enables you to display it is not a functionality that is independent of its appearance. Now, it is, I would suggest, worth noting that this is a question with which neither the United States nor the German courts have had any difficulty. Some legal systems, such as those of France and the Netherlands, do not distinguish between artistic and functional aspects, allowing copyright protection to both. The major jurisdictions which are based on that distinction are those of the United Kingdom and the English law Commonwealth, Germany, and the United States. I'm sure there are others, but those are the ones that are best known for it. Now, in the Hamburg Court of Appeal case, Maschinenmensch, that arose out of the Metropolis film, the court classified the get-up of the actress Birgitta Helm as fine art and sculpture. Now, that as the Court may recall, is at Bundle 3, flag 26. And the critical paragraph is paragraph 2 of the judgment of the Hamburg Court of Appeal. Now, the question that they asked themselves, as one can see from paragraph 2, one of the questions they asked themselves, is what contribution to the appearance the actress herself made to it. And what they said, just at the break of the page in the middle of paragraph 2, was the traits taken in casts from the actress Brigitte Helm only constitute part of the character. The other part was freely created, so that its creation is not limited to a purely manual activity. As a work of fine art, the sculpture of the human robot constitutes a protected work. Now, the Hamburg Court of Appeal was not applying an elephant test, or indeed a test of asking whether Brigitte Helm would have said, "Today I have been on the set wearing a sculpture." Yet the get-up of the actress was undoubtedly worn. It had that much in common with a costume. And no doubt it had all the features necessary to make it easy and comfortable to wear. The actress in the case of the Metropolis get-up was a much more recognizable feature of the robot woman, as one can see from the poster in front of you, than the helmets and armour are in this case. The court obviously considered, therefore, whether those aspects of its appearance which were derived from the appearance of the actress were significant enough to deprive the visual impression made in the film of the character of fine art. Now, in other words, they were asking, is this an actress with a costume, or is it a sculpture with an actress whose function is to display it? And they gave the latter answer. The essence of the visual impact here is being made by the get-up. Now, that reasoning does not, as I think my learned friend was inclined at one point to suggest, does not depend on anything so unprincipled as the fact that its creator happens to be well known as a sculptor. This was, in our submission, a principled decision because it concentrated on what mattered, namely the intention to make a visual impact and the fact that the functionality of this object was no more than the way in which it achieved the intention of making a visual impact. Now, it is in our submission exactly the same exercise that was being performed in the United States Third Circuit case of Masquerade, which is not an obscure byway of American jurisprudence, as you saw from the Copyright Office notice that my learned friend read to you this morning. It has altered the way in which the Copyright Office operates in relation to such objects. Now, Masquerade was concerned with something that a person had to wear. And that also, the animal masks presumably also had features designed to enable the wearer to see, to hold the mask on his head, to be reasonably comfortable while doing so, and so on. But none of that was consistent because it was all part of the function of displaying the mask. Now, that was also, I suggest, a principled decision on the irrelevance of a function which is simply the way in which an object achieves its visual effect. And it's a particularly telling example because we have seen that the United States Copyright Act protects exactly the same list of objects as the United Kingdom Copyright Act. There are some differences between US and UK law on this, but they're not fundamental and they're not relevant to the issues we're concerned with. Now, the only relevant distinction that my learned friend could point to between US and UK copyright law is that he says US law has a more absolute insistence on the exclusion of useful objects and a more rigorous exclusion in particular of costumes. Now, if that is so, if it's true that US law is particularly tough on useful objects and clothing, but nevertheless classifies extravagant animal masks as sculptures, then why should the result be any different in England? If my learned friend is right in the submissions that he has been making to you, then although English copyright law has substantially the same underlying purpose as that of the United States and Germany, and protects the same articles on the same basis, nonetheless, extravagant three-dimensional objects which are worn for display are treated differently in England. Now, in our submission, that is a result which ought to cause this court concern. The court should, I suggest, be particularly concerned about reaching that result in the manner in which my learned friend proposes, because if you do, the outcome will be that a difference will have come about between courts seeking to apply similar legal principles to the same broad issue, which will be due simply to the application of the elephant test in England, instead of the application of basic principles as the US and German courts have done. Now, in my submission, one does not get to the question whether the test is overwhelmingly artistic or predominantly artistic unless there is a truly functional purpose which doesn't just consist in the mode of display of the object. Unless there is a truly functional purpose which doesn't just consist in the mode of display of the object, then there is no contradistinction between the fundamental and between the functional and the artistic, which calls for one to decide whether the relationship between them has got to be overwhelmingness or, as we submit, predominance. So in our submission, one doesn't get to that question in the present case with an object which has no relevant function. But I will, albeit briefly, answer it anyway. In my submission, the overwhelmingness test is not a practical, workable test unless you make a major value judgment, and it will not achieve the object of protecting truly artistic works. The Trevi fountain, which we mention in our printed case, and my learned friend has mentioned in his submissions, was not conceived as an overwhelmingly sculptural object in which the functional purpose was insignificant, a matter of the odd horse drinking at the fountain. It was the means by which one of the largest aqueducts supplying Rome was delivered to the population of Rome at a time when there was no domestic piped water and public fountains were the sole source of water for drinking, washing, and everything else. To take another example, how is one going to say that the caryatids on the Erechtheion, in the form of sculpted ladies, have no significant function when they hold up the building that would otherwise fall down? The reason why they are sculptures in my submission is that although they hold up the building, their particular appearance and form is primarily, but not perhaps overwhelmingly, due to an intention to make a visual impact. They actually illustrate the fact that a sculpture may have a highly significant, indeed absolutely critical, functional purpose and yet be a sculpture because its prime purpose is for display. Now, descending, if I may, from the sublime to the ridiculous, the same is true of other sorts of objects of a humbler sort that have been considered in the cases, like the sculpted lamp bases considered by the Third Circuit Court of Appeal in Masquerade, which were sculptures, notwithstanding that they had been made to hold up lamps. Now, it's quite right to point out, in addition to that, that the 1988 Act draftsman seems to have assumed that the test was a primary purpose. I say that, and it may be a very slender indication, but it is nevertheless of some interest, that in section 52.4, which is the section that empowers the Secretary of State to make orders excluding certain items from the scope of section 52, the power is to exclude from the operation of this section such articles of a primarily literary or artistic character as he thinks fit. And that appears to reflect the assumption of the draftsman that you could have something that had some functionality, but which was nevertheless not its main function. Now, my learned friend has a further argument, which is a variant of the elephant test, and consists in saying that acceptance of my case would be absurd because it would mean that every three-dimensional object made specifically for a film would be a sculpture. Now, the suggestion is, well, you can't have too many elephants blundering around the same room. Now, he says that the only alternative to that unattractive elephant farm scenario is that you have to accompany him to the opposite extreme and say that the pretended function of every object should be treated as if it were the real function. Now, the problem about that is that if the purpose of a three-dimensional prop with no real function is to pretend that some function is being performed, to give the viewer an illusion that it is being performed, then that is only another way of saying that an artistic illusion is being created by the visual impact of the object. And the creation of illusion by visual impact is surely a classic function of art and perhaps of sculpture in particular. Now, I don't submit, as my learned friend suggested, that every three-dimensional article made specially for use in a film is a sculpture. First of all, it's got to be original and not merely derivative, a feature which my learned friend describes as disappearing, but I respectfully suggest that that is not a fair way of describing what constitutes originality as laid down in the principal modern authority on it, which is the decision of the Privy Council in Interlego. Lord Oliver's judgment in that case, in particular pages 262 and 263, makes it perfectly clear that the application of skill, judgment and labour is not always enough to satisfy the requirement of originality. Now, secondly, many items are made specially for a film, but are nevertheless functional items, and nonetheless so for being made for a film. A desk, for example, may serve the utilitarian purpose of being sat behind by a character in the film and written on, and he may be sitting on a chair that serves the utilitarian function of being sat on. Now, if the film producers have used a desk and a chair which had been bought from a furniture store, then clearly it would not be a sculpture. If they made the desk and chair specially for the film, it would, in my submission, still not be a sculpture. It would just be a functional object which happened to be used in a film. And that would be a real function, not a pretended function. The artist would actually be sitting behind the desk and writing on a piece of paper, and he'd actually be sitting on the chair.
How about a lamppost for a scene that takes place in daylight?
How about
a lamppost for a scene that takes place in daylight?
Yes. Is your lordship envisaging that the lamppost is specially made for that?
Yes.
Well, it is. You have the lamppost is there. It is daylight. You don't say that the lamppost is not a functional item simply because its function is only being performed at certain times of day, and this isn't one of them. In my submission, that would be a functional item as well. The stormtroopers' helmets and armour...
Even if it wasn't connected?
If it wasn't connected, I think it probably would be a functional item then. You may not be using its functionality, but it would be functional. A better example, closer to the bone, so to speak, might be my learned friend's example of the side of a car without an engine, which is designed to create an illusion of there being a parked car. It's simply the direction from which the camera looks, and I'll say a word about that in a moment.
But if it was a policeman's uniform,
yes.
Then it would be functional if it had been a policeman, but it wouldn't be on a policeman.
No, it would be functional if it was an item of clothing, for the reason that I've already given when dealing with the question of clothing. Now,
including the helmet.
Sorry,
including the helmet.
Same would apply. Now, I would suggest that my learned friend does come slightly closer to the point with his examples about objects which are not functional, because they're designed to create the illusion of functionality without the reality. So the prop consisting of the side of a car towards the camera, but without an engine or indeed another side. Now that is sculpture, because its purpose is to create by exclusively visual means an artistic illusion, and it has no function either within or outside the context of the film. Now, whether it would have any commercial value for merchandising purposes must be highly doubtful, but it would be technically protected by copyright. Now, I would have been interested to know what my learned friend's case was about the example which I gave when opening, about the moulded polystyrene stage backdrop of a row of houses with an oriel window, taking up the example given to me by my Lord Mance. I think it has to be his case. That is not protected as an artistic work, although a painted backdrop in 2 dimensions would have been. And that, I would suggest, is the kind of distinction which discredits the law, and it comes of trying to decide questions like these while losing sight of the underlying purpose of artistic copyright. Now, if I may briefly refer in this particular context to my learned friend's hierarchy of worthiness and to his suggestion that the helmets and armour should be protected only by industrial design right, since it's worth just looking at that, since it perhaps supplies some kind of reality test. Industrial design is comparatively short because, as my Lord Phillips suggested and my learned friend confirmed in the course of an intervention yesterday, it does matter if people are prevented from using a particular design for too long, that is functional in some way that effectively confers upon him a monopoly over an ordinary item of daily life. Now, artistic copyright, by comparison, is available for objects where no great economic harm will come of preventing people from copying a work of art or a work of literature for 50 or 100 years 50 or 70 years after the death of the creator. It doesn't matter, socially or economically, if people are unable to copy a sculpture with no significant functional purpose other than to be displayed. They can make their own sculpture. Now, it doesn't matter if people are unable to copy the artistic features of an item such as a sculpted lamp base, which has a function as well as being made primarily for display. It doesn't matter because you can still reproduce what is functional about the sculpted lamp base because it's independent of its appearance. In other words, you can make different looking lamp bases and no harm is done, no monopoly is indirectly created. The truth is, it doesn't matter to the development of innovation if people are prevented from copying these helmets and armour. They can invent their own fancy film props if they need them. Now, on the other hand, it does rather matter if the loss of copyright protection contributes to drying up the merchandising stream of revenues from a very high risk and highly artistic activity, such as filmmaking. It matters if those like George Lucas, who devise original and striking three-dimensional objects, devoid of any significant functional purpose other than to be displayed, cannot exploit their imaginative act of creation commercially because the rest of the world can appropriate it for themselves. And in that context, it is actually quite important to get away from the instinct which my learned friend was anxious to encourage in the court, that copyright is something reserved for a particularly select group of works, therefore, by implication, not in anything so inferior as a film. Now, my learned friend says that the 1911 Act was designed to assimilate sculpture to literary works and musical compositions, with the implication that they must be things of some grandeur. Now, the reality is that copyright works of absolutely no interest, merit, or commercial value are being created all the time, quite often by accident. That is the consequence of the exclusion of artistic quality as a relevant factor, explicitly in the case of artistic copyright, but implicitly in all branches of copyright law. Now, if the object of the 1911 Act, as my learned friend says, was to assimilate sculpture to literary copyright, it is of some interest that literary copyright may be created for perfectly ordinary writings which have no pretensions to be works of literature in the ordinary demotic sense of that phrase. My notebook is a literary work. I wouldn't go round saying I have just composed a literary work. But that is nevertheless what, as a matter of copyright law, I have done. Every child who in a school art class models figures out of clay and plasticine at school is creating a sculpture which is protected as an artistic work should anybody care to exploit its commercial value. Now, the great majority of items which are protected by copyright have no commercial value at all, and the fact that they are copyright protected has no practical significance, just as the fact that copyright attaches to the side of an engineless car designed to create the illusion of a car in the film has no practical significance. But this court, in our submission, should not be deterred from holding that copyright attaches to a creative object with a very high commercial value, such as the helmets and armour in this case, by the consideration that the same test would give copyright protection to a large number of objects that nobody cares a fig about or would ever be likely commercially to exploit. Now, may I at this point turn to the question of works of artistic craftsmanship? My learned friend says under this head that since the helmets were found by the judge to be works of a craftsman, Mr. Ainsworth, the fact that they were not works of artistic craftsmanship can only be because they weren't artistic enough. Therefore, a fortiori, they cannot have been artistic enough to be sculptures. Now, the first point to be made about this is it's perfectly possible for the same object to be both a work of artistic craftsmanship and a sculpture. These are not mutually exclusive categories. However, what should be said is that the practical usefulness of the distinct category of works of artistic craftsmanship is that it extends to a range of objects which would not be protected as sculptures because they are primarily functional. And although work of artistic craftsmanship may include sculptures, its real value and the reason for including it in the Copyright Acts is that it extends protection to things that aren't sculptures because they are functional.
But if the object is crafted,
yes.
Can it be a sculpture if it's not also a work of artistic craftsmanship?
Your Lordship is suggesting that every sculpture must also be a work of artistic craftsmanship. I don't think that I would accept that. The requirement of craftsmanship has proved a particularly difficult concept to apply, and there are some techniques for creating sculpture that wouldn't necessarily be regarded as craftsmanship.
I said if it is crafted, so that you take the craftsmanship out.
Yes.
Is it ex hypothesi going to be artistic if it qualifies as a sculpture?
No, not necessarily, because the category of works of artistic craftsmanship assumes that you have to satisfy. I mean, it's not quite right to say there are two separate requirements, craftsmanship and artistry. The way in which it was put in Henshaw was it has to be the work of an artist craftsman, and there is a relationship which is very imprecisely defined in the case law between those two exercises. But my learned friend's argument is actually rather cruder than these slightly subtle considerations. He is simply saying if it's not a work of artistic craftsmanship because it's not artistic enough, although it's craftsmanlike, then it can't be a sculpture. Now, that in our submission is wrong. Works of artistic craftsmanship include objects that will not qualify as sculptures because they are functional, but which have, as the High Court of Australia put it in Burge and Swarbrick, an artistic aspect which is independent of, unconstrained by, as they put it, their functionality. Now, helmets and armour, like the ones we're talking about here, are not functional objects in any meaningful sense. Their visual appeal is not an aspect of their appearance independent of their functionality, which is the issue that arises in works of artistic craftsmanship. It's the whole purpose of their appearance and form, their visual appeal. Now, if, contrary to my submission, you treat the helmets and armour as functional because they were created for use in a film, then, of course, it becomes impossible to say that its visual impact is unconstrained by its function. If use in a film is enough to make something functional and not artistic, then one would have to accept that you can't disentangle the visual impact from the functionality. Now, the judge in this case, Mr. Justice Mann, thought that these objects failed the test for sculpture because they were functional. And the visual impact that they made was irrelevant, he said, because that visual impact was wholly for the functional purpose of being used in a film. Now, I have challenged that reasoning, but if it is right, then it is just as inconsistent with the helmets and armour being a work of artistic craftsmanship. And that is actually what Mr. Justice Mann thought, because if you take his judgment from the core volume, at paragraph 121, he says, and we have discussed this several times, he said that it was designed to create a visual impression of force, menace, purpose, and the rest. But while it was intended to express something, that was for utilitarian purposes, the utilitarian purpose being for use in a film. While it has an interest as an object, and while it was intended to express an idea, it was not conceived with the intention that it should do so otherwise than as part of character portrayal in a film. When one turns on to paragraph 134, where he expresses his conclusion about work of artistic craftsmanship, he effectively rejects the artistic aspect of that issue on exactly the same ground. He says at the beginning of 134, I don't consider that they're works of artistic craftsmanship. So far as their conception is concerned, they were plainly not. Their purpose was not to appeal to the aesthetic at all, it was to give a particular impression in a film. So the judge's ground for rejecting works of artistic craftsmanship is the same under both categories. I have submitted that the error that the judge made was to treat what is actually the manner of display of the object as if it were a function to be opposed to its artistic purpose. Now, if the judge was right about that, then he was right about it in both paragraphs, and if he was wrong about it, then he was wrong about it in both paragraphs. I'm not sure it adds anything to say that we can't succeed on sculpture if we don't succeed on works of artistic craftsmanship. And the court should, I suggest, bear in mind that in both Germany and the United States there is a category of works of artistic craftsmanship. They are protected under that name in the US Copyright Act of 1976, and they're protected under the name of applied art in Germany, which my learned friend in his printed case accepts is a category substantially corresponding to works of artistic craftsmanship. Nonetheless, the Third Circuit Court of Appeal in Masquerade classified the masks as sculpture rather than works of artistic craftsmanship. And the Hamburg Court of Appeal classified the robot woman's get-up as sculpture and as such as fine art, not as applied art. And those were, in our submission, principled decisions.
But I think it then follows from that argument that the fact you haven't appealed against the finding that it's not a work of artistic craftsmanship doesn't preclude you from saying, but if it's necessary for it to be that in order to be a sculpture, then we say it is that.
Absolutely not. I mean, the reason I haven't appealed it is that works of artistic craftsmanship add absolutely nothing to my case in the particular circumstances we're concerned with. Now, Section 52, under this head, my learned friend had one argument on the facts and one argument of construction. The argument on the facts is that there was actually an intention to multiply industrially at the outset, and that was based on what the document that the court finds at tab 13 in Authorities Volume 6, although it's not actually an authority, it's a witness statement from Mr. Howard Rothman. And he relied on paragraph 5. Now, I don't wish to take time up on this, but what paragraph 5 says is that Lucasfilm understood the significance of merchandising rights early on. They would have liked to retain the merchandising rights at the time of the first Star Wars films for which these artifacts were made, but in the event they had, as a matter of commercial pressure, they had to assign them to the studio, and they only got them back at the time of the sequel, when no doubt their bargaining power was rather stronger. Now, there is a world of difference between, as Mr. Rothman puts it, understanding the importance of merchandising rights early on and intending to multiply these particular objects industrially, i.e. creating them for that purpose. No doubt my clients would have liked the right to such merchandising as might later prove to be worth doing. But it wasn't until they discovered whether it was worth doing that the relevant intention was formed. And as Mr. Rothman says, we did not even have the merchandising rights until the sequel was made. Now, that, in our submission, doesn't carry one anywhere. This question needs to be decided on the basis of the judge's findings at paragraph 185 of his judgment, which I have referred the court to. The judge did not accept every aspect of our evidence, though he did accept quite a lot of it, and that is the finding that he made. Now, the argument of construction is this. It's an argument which is addressed to the possibility that this court might find that the full-size helmets and armour are sculptures, but that the toys aren't. And if the toys are not sculpture, says my learned friend, then the exclusion order of 1989, which excludes sculpture from the ambit of Section 52, doesn't apply. In that case, says he, the effect of Section 52, if the court has Section 52 open in Volume 1, the effect of Section 52 is that it's not an infringement for my learned friend's client to make copies even of the full-size helmets and armour. He says if the toys aren't sculpture, and we've multiplied the toys industrially, then the result is that because Section 52.2 says that it's not an infringement to copy the work by making articles of any description, therefore the fact that we have industrially marketed copies consisting of the toys means that they are entitled to copy without infringement the full-size articles. That's the argument. So if the toys aren't sculptures, and we make them in industrial quantities, they become entitled to make the full-size replicas as well, even if the full-size replicas are sculptures. That's what's being said. Now, there are two problems about that argument. The first is that the toys are in fact sculptures, notwithstanding that they are there to be played with. That is what Britton and Hanks decided. The attempt of the Court of Appeal to distinguish Britton and Hanks on the ground that the toys in that case were really collector's items is totally unsupported by the report of the case, either the report of counsel's argument or the report of the judgment. And it should be noted that in spite of what my learned friend says is the rigorous exclusion of useful objects from copyright protection in the United States, toy models have been classified as sculptures in the United States as well, which is clear from the decision about them discussed by the Third Circuit Court of Appeal in Masquerade, the extra paragraph, which cited extensively from a decision about toys. And there are actually many examples of this in US jurisprudence relating to dolls, rocking horses, soft animals, and the like. And that is because their utility as things to be played with will often derive wholly from their appearance. Now, this point about the toys depends upon my learned friend persuading the court to depart from Britton and Hanks on the ground that being played with is a functional purpose which deprives the toys of their artistic status. Now, I do not say that all toys are sculptures. In some cases, the function of being played with may be inconsistent with its artistic status because it's a function which is not connected to the appearance of the object. This is a question that really depends on whether the appeal of the object as a thing to be played with derives from its visual impact, i.e. its appearance, or from some functional characteristic independent of its appearance, such as its tactile qualities, its ability to be cuddled, and so on. But model soldiers, and the same applies to the toy stormtroopers here, are generally played with because they are visually attractive as models. Other toys, like dolls whose attraction is to be fondled, or model railways whose attraction lies in their mechanical functions, are more marginal issues. One would need to look at the facts of each case. But these models derive their utility as toys from their appearance and from nothing else. Now, the second difficulty about this submission of my learned friends is that Article 3.1a of the 1989 order only really works, his argument only works if you ignore the proviso to the exclusion order of 1989. If the court would just refer for a moment to the exclusion order, which is at flag 3 of volume 1 of the authorities, assume for a moment that the full-size helmets and armour are sculptures, which is the premise on which this argument arises. On that footing, Article 3.1b of the 1989 order takes them out of the scope of Section 52 altogether, provided that they were not used or intended to be used as patterns to be multiplied industrially. Now, it follows from that provided that they were not used or intended to be used in that way, the industrial multiplication of the full-size helmets and armour in the form of toys does not have the adverse effects provided for by Section 52. Now, they weren't intended to be used as patterns or models to be multiplied industrially, among other reasons because Kleeman had held that such use or intention had got to exist at the point of the design's creation, so that if one gives effect to the proviso to the exclusion in the article, then you have to give effect to words which are identical to those construed in Kleeman. Now, my learned friend's response to that was to tell the court that the words of the proviso, which are exactly the same as those considered in Kleeman, have been included by mistake and ought to be ignored. With great respect to him, that's an impossible contention. These are the same words that were used in a similar context in Section 22 of the Copyright Act 1911 and in Rule 26 of the Design Rules 1949. In Section 22 of the Act of 1911, their effect was to ensure that in spite of the exclusion of articles registrable as industrial designs, copyright protection was maintained for designs which weren't intended to be multiplied industrially. And those were the words construed by the House of Lords in Kleeman. Now, the effect of that scheme was then reproduced by Rule 26 of the Design Rules 1949, which is at Authorities Bundle 1, Flag 24, which uses exactly the same words. It excludes from registration under the design legislation works of sculpture other than casts or models used or intended to be used as models or patterns to be multiplied by an industrial process. Now, in Section 22 of the Copyright Act 1911, which was in force at the time that these design rules were made, the effect was to ensure that in spite of the exclusion of articles registrable as industrial designs, copyright protection was maintained for designs which were not intended to be multiplied industrially, because such designs were not registrable as industrial designs and therefore were protected, where they weren't excluded from copyright by Section 22. So, in other words, the effect of the scheme was reproduced by Rule 26. Now, the Gregory report, which the court was shown yesterday, you needn't turn back, it's at flag 3 of bundle 2, that preceded the Copyright Act of 1956, and it recommended that Kleeman should be reversed by removing Rule 26. That recommendation was made at paragraph 263 of the report. Contrary to the suggestion that I think that was being made by my learned friend, that proposal was not adopted. When the Copyright Act 1956 was enacted, it contained in Section 10 provisions approximately corresponding to Section 22 of the earlier Act, which excluded from copyright protection registrable designs. And Section 10.4 of the Act of 1956, however, excluded from these particular restrictions in Section 10 anything that was excluded from registration by the design rules. So Section 56.4 said, if something's excluded from registration by the design rules, then Section 10 won't apply to it. That was the predecessor of Section 52. Now, because Rule 26 of the design rules was left unamended, the effect of that was that the Section 10, didn't apply to sculptures at all, unless they were casts or models intended to be multiplied industrially. Now, Section 52, that this court's concerned with, is the functional successor of Section 22 of the 1911 Act and Section 10 of the 1956 Act, although it achieves the same objective in a slightly different way. Instead of operating by reference to what is included or excluded from the design rules, Section 52, together with rules made under it, contains its own code. And the language of Rule 26 is not to be found in Section 52 itself, but it is reproduced in the exclusions in the order made under Section 52, its object quite clearly being to achieve exactly the same effect. They haven't been included by mistake, and they can't be ignored in the way that my learned friend invites this court to do. Now, if I may very briefly deal with the question of jurisdiction or justiciability according to taste. My learned friend has used both at different times. I wish to make, if I may, just some brief discrete points, mostly by way of correction to particular questions. I should start by pointing out that the infringement for which Mr. Ainsworth and his company were liable in the United States was not limited to placing 3 advertisements in New York newspapers. The main head of infringement was importation into the United States, for which Mr. Ainsworth and his company were liable either as being the importers or as a joint wrongdoer with the importer. And that was why Mr. Justice Mann made an injunction which prevented Mr. Ainsworth and his company from selling into the United States. That order is in the bundle. But secondly, my learned friend's points about registration under the US Copyright Act, which were relied upon as showing that an action in England on a US copyright would involve a challenge to a governmental act because of the process of registration. Now, this is a little, my learned friend hasn't with respect got this right. As my learned friends, a number of points have to be made about this. First of all, as my learned friend, I think, said, the United States is probably unique in the world in requiring registration for any copyright, except in the case of works originating outside the United States. The parties to the Berne Convention undertake not to apply any such formality to foreigners. And the bifurcated system, under which there's a different principle for works of US and non-US origin, is a peculiarity of the United States. Now, it's not easy to see how this particular idiosyncrasy of US copyright law can affect the question whether the English courts have subject matter jurisdiction over foreign intellectual property rights in general. Secondly, the unchallenged evidence before Mr. Justice Mann, and I wonder if I may hand up some copies of this. I'm sorry to be introducing this at this stage, but I had not appreciated that my learned friend was going to make this point. What the court has now been handed is an extract from Day 6, which was my learned friend's cross-examination of Professor Mennel, who was our expert on US copyright law. And he was asked about registration and said at line 4, registration is not a requirement for copyright protection. It's a prerequisite to bring a lawsuit under the Berne Convention, which the United States has joined. We don't have formalities to copyright protection. So those are issues that I think are somewhat beside the issue of what the court's responsibility is. The court is merely deciding whether there is copyright protection and whether there is infringement. And further down on page 42, you are required to register to bring an action in the US courts for a work of US origin. Now, the unchallenged evidence before Mr. Justice Mann was that registration was not a prerequisite to the subsistence of copyright at all, even in the case of a work of US origin. It was a prerequisite to the right to sue for an infringement, but you could conserve that right by registering at the time of suing. Now,
would that be regarded as a question of procedure? And therefore
exactly. This is a procedural prerequisite to the right to bring an action in the US courts. It has absolutely nothing to do with anything else, and it, of course, would have no application in a case where the lex fori was that of the English courts in the event of a US copyright action being entertained. Moreover, it is perhaps right to add that after the trial, the Supreme Court held in the United States that non-registration isn't actually even a prerequisite to the United States court's jurisdiction to hear the dispute. That was decided in a case which, if the court is curious, it will find in Volume 3, Flag 34, called Reed, Elsevier and Muchnick, where the relevant passages are between pages 2 and 6. Now, this is a purely procedural condition on the right to bring suit in a US court. It's, in our submission, therefore irrelevant. That is why Mr. Justice Mann, although referring to a requirement of registration in paragraph 268 of his judgment as something which might make a copyright analogous to a patent or a trademark, in fact then goes on to ignore that requirement completely in analysing the nature of a copyright and the application to it of the Mozambique rule. He did that because Professor Manuel's evidence completely removed the registration factor as a relevant consideration. Finally, as applied to this particular case, of course, the registration requirement would in any event only have applied to the Macquarie paintings because they were the only works of US origin. The helmets and armour were themselves works of non-US origin. Now, if I may just trespass a little bit over 4 p.m., I shan't be more than a very few minutes. The next point is that my learned friend's submission is that it is for Parliament and not this court to extend the jurisdiction of the courts. I want to make it clear that I am not contending for any extension of the jurisdiction of the courts. My case is that the courts have jurisdiction on ordinary principles of general application on the basis that if personal jurisdiction is established, the English court has jurisdiction to decide any claim to a foreign civil wrong applying the appropriate proper law. I submit that there is no rational ground for recognising a special rule for intellectual property rights, at any rate as regards copyrights and questions of infringement as opposed to validity. A breach of a foreign statutory rule prescribing infringement remedies for copyrights is, in our submission, not local, simply because the territorial ambit of copyright laws in most countries is limited to the foreign state in question. If that were enough to make an action local, then the rule for which my learned friend contends would also apply to claims for breach of any foreign statutory wrong, because any foreign statutory wrong will be limited to the jurisdiction of the country enacting such a wrong, and it will certainly not be recognised by other countries' courts as entitled to any application outside the territory of the enacting court. The problem about my learned friend's submission is that he has not been able to point to a single feature of copyright infringement litigation which is not equally true of other foreign civil wrongs which are routinely tried in the English courts. In particular, the fact that the foreign law is limited in its application to the foreign jurisdiction and the difficulty in some cases of deciding what the foreign law is are absolutely routine features of English litigation.
Until 1995, this really wouldn't have been a problem because the foreign law would have had to be parallel with English law.
Well, indeed, so the question couldn't have arisen. That is absolutely right. But non-justiciability is a concept which can have the effect of damaging a remedy or denying a remedy for an established wrong. And for that reason, the English courts in our submission do not promiscuously create new heads of non-justiciability. They do so only for reasons of overriding public interest, such as those which arise out of the relationship between different states, fundamental principles of comity, such as those which the House of Lords considered itself to be applying in Mozambique. And in that particular context, taking up a point, an exchange between my Lord Collins and my learned friend this morning, I would not accept that there is a relevant difference in the context we're concerned with between non-justiciability and lack of subject matter jurisdiction. It's perfectly true that limitations on the national jurisdiction of particular courts under Article 22 of the EU Judgments Regulation are limitations on jurisdiction and are not based, for the most part, on justiciability. But there is no difference between lack of subject matter jurisdiction and non-justiciability in the context with which we are concerned, where there is personal jurisdiction over the defendant. I should point out also that although Mozambique spoke in terms of jurisdiction, its extension to intellectual property rights can only be justified by reference to something analogous to the Act of State doctrine, and that is clearly a classic form of non-justiciability. It was the basis on which Potter was decided in Australia, citing the famous United States Supreme Court decision on Act of State, namely Underhill and Hernandez, and it's the way in which it was correctly analysed in Over Arap. Voda and Cordis, if I may make 3 brief points about that. The whole analysis that the court was read from Voda and Cordis was directed to a discretionary power to refuse to exercise jurisdiction or to accept supplementary jurisdiction. The exercise was therefore equivalent to forum non conveniens. The heading is discretion. And paragraph 6 of Voda and Cordis applies the classic test, or what we would regard as the classic test of forum non conveniens. What it says is, Voda has not shown that it would be more convenient to have this matter tried in the US than in England, and Voda has not shown that it won't get justice elsewhere. Those are, of course, the classic questions that are asked in every forum non conveniens claim, and if they had shown them, the result would have been different. Secondly, if the court in due course reminds itself of the reasons given by the majority for referring to the local character of the cause of action in that case, their analysis was wholly directed to features of patents which are not present with copyrights, in particular to the aspect of the challenge to the administrative procedures involved in the grant by the state of a patent. And it's only in patent cases, it's right to point out, that the practice has arisen of suing in every jurisdiction separately, largely for that reason that you usually end up having a dispute about validity, and there is a serious argument that that should be reserved to the court of the jurisdiction in which the patent was granted. Finally, on Voda and Cordis, the dissent of Judge Newman, whether she be a lady or a gentleman, makes no difference for this purpose, is very well written and very pertinent to the issues that we have been discussing, and makes many of the points which I respectfully suggest to an English lawyer would be regarded as more persuasive. The impact of Owusu on forum non conveniens is, in our submission, a non-point. The fact is that either Owusu applies to the particular case, in which case, if the defendant is domiciled in an EU member state, then jurisdiction must be exercised there, or if it's domiciled in England, jurisdiction must be exercised here, or else Owusu doesn't apply to the particular case, in which case forum non conveniens will supply an altogether more satisfactory answer to these supposed problems than anything which my learned friend has proposed. All that remains for me to do is to adopt with respect the observations made by my Lord Collins about Rome II, Article 8. It does clearly assume the exercise of national jurisdiction over foreign intellectual property rights may be appropriate. It cannot relate to the exception from the common law rule relating to personal obligations because it is limited to non-contractual infringement claims. It dates, of course, from 2009, well after the cause of action arose here, but it reflects what most lawyers would unquestionably assume must always have been the position, and in our submission was. I apologise to the court for having overstepped the time limit by a small amount.
The court is grateful to counsel for their submissions and will reserve its judgment.